Good afternoon, everyone. Thank you so much for being here today. Let's begin with a few introductions. My name is Kellie Walters. I am a staff attorney with Legal Services for Prisoners with Children. Delaney, Caleb, Caitlin, do you want to introduce yourselves?
Sure. Hi, everyone. I'm Caleb Indra. I'm a second year law student at Berkeley Law School and part of the Policy Advocacy Clinic there. And we helped DFJC, Deaf Free Justice California, our main client, pass AB 1186. So we're excited to talk about it here today.
Hi, everyone. My name is Caitlin Anderson. Similar to Caleb, I am a 2L. I am also in the Policy Advocacy Clinic at Berkeley Law, and we're really excited to do this training. So thank you all for joining, and I'll hand it off to Delaney.
Hi there, my name is Delaney Green. I am a clinical supervisor with the Policy Advocacy Clinic at UC Berkeley Law. And yes, here on behalf of our wonderful client, Debt Free Justice California.
Nice, thank you. Well, we're here today to discuss an important shift in California's criminal legal system, the implementation of Assembly Bill 1186. That is a law that changes how restitution fines are applied and collected, especially as they relate to youth and longstanding debts. Sorry. This presentation will offer a brief overview of restitution as a whole, break down the core changes introduced by 1186, and explain how these changes affect impacted individuals and families. We'll also go over practical steps people can take to find out what they owe, request relief, or get support from legal service providers. AB 1186 marks a significant step towards reducing the financial burden imposed by the justice system, particularly on young people and those who have carried restitution debt for over a decade. These reforms reflect a growing recognition that restitution fines can often create long-lasting economic harm without improving accountability or supporting true healing. As we go through the slides, I encourage you to think about how these changes might affect your clients, your communities, or your advocacy. There's still restitution in place, but this law changes how, when, and to whom certain financial penalties apply. Let's get started by grounding ourselves in the basics. What exactly is restitution, and how does it differ from restitution fines? With that, I will hand over the proverbial mic.
All right, thanks everyone. I will be handling the next couple of slides, and then I'll be handing it off to Caleb. So first, let's just go over sort of the basics of Restitution 101. So there are two different types of restitution. First is restitution paid for victim compensation. Basically, if victims have any harm that results from the offense, this is paid specifically to those victims, and honestly, more likely through the restitution fund, because as you'll see, a lot of people cannot actually pay for restitution themselves. And this is separate from restitution fines. Restitution fines are more of an administrative add-on to restitution. And at times, restitution fines will be assessed on a person even if there is no actual restitution. So these are mandatory fines that are used to help with implementation of restitution and pay for restitution victim assistance programs. All right, so next we'll go over the basics of what AB 1186 does. There are four main provisions. First, it eliminates youth restitution fines and not restitution orders. Second, it cancels and makes youth and restitution fine debt older than 10 years unenforceable or uncollectible. Third, it requires less expensive restitution amounts between repair or replacement. So, and this is what Caleb will get into later, but previously there was a little bit of confusion as to what the judges should order, whether it's the cost of replacement or repair. And so now it is the lesser of the two charges. And then finally, AB 1186, or the Repair Act, actually ends joint and several liability for youth co-defendants. And so going into the first part, AB 1186, the Repair Act, actually eliminates going forward and from January 1st, 2025, youth restitution fines. So remember that there are still victim restitution, and that is wholly separate and is not touched by AB 1186. So if your client is still ordered to pay victim restitution, that is still enforceable. However, the mandatory restitution fine that was added on top of, or sometimes wholly apart from restitution, is not itself in effect anymore. And so they will no longer be assessed after January 1st of this year. And if you have any pending cases, you may not have to pay them. And it also, this law might apply retroactively. So because of certain laws, or certain cases in Rea Strata or in Re Hunter, ameliorative laws or statutes that reduce punishment for criminal conduct apply retroactively to all defendants whose sentences are not final. So this means that if the case is still pending, even if your client is still on probation, you could make the argument that this applies retroactively. And we have actually seen legal practitioners successfully argue this. If you have any follow-up questions about that, we are happy to give you that information, send you some briefings, send you memos on that as well. Next slide. All right, and then the second provision before I hand it off to Caleb is that the Repair Act vacates restitution fine debt older than 10 years, and it does this for both adults and juveniles. So courts should cease collection and solicitation of payments for all restitution fine 10 years or older, even if it is currently in collections. All right, and so with that, I am going to hand it off to Caleb for the remaining two provisions.
Thank you, Caitlin. Yeah, so the final two are more technical changes with positive substantive outcomes. So we're probably going to go through these a little bit slower than the other two just because they're a little more complicated. So the third change is that AB 1186 clarifies the property loss calculations for youth restitution orders. So that's restitution orders, not the fines. So the actual restitution amount that you have been assessed as a juvenile or your client has been assessed. So what that means is when a juvenile court assesses restitution for property damage, they must determine the restitution amount based on the value of repair or replacement, whichever is less. So we have an example here. If I steal a car and steal and crash Asher's car, repairing Asher's car is $1,000 and buying a new car is $35,000. I must be ordered to pay $1,000 in restitution, even if the victim or survivor wants to buy a new car. Even in fact, if they actually do and go ahead and buy a new car, they will only be awarded $1,000 of restitution because that is the lesser amount. Next slide, please. So what does this actually mean? Previously, juvenile courts were able to determine restitution based on either the cost of repair or cost of replacement. So what we saw was happening was courts were permitting the higher cost and then kind of giving survivors and victims a windfall payment. So in that example I just gave, they could be assessed an evaluation of $35,000 instead of the $1,000 of actual damage, which is categorically unfair based off of what actually happened in terms of the damages. So now the court actually has to take into account which is lower, and that could be either replacement or repair, depending on the context. Sometimes replacement is cheaper than repair for given things. Regardless, they have to assess the lower amount and have a more accurate evaluation of damages or losses. Next slide, please. And then the final thing that AB 1186 does is it ends joint and several liability for youth co-defendants. Again, that's some technical language. So what does this actually mean? It means if multiple youth are assessed restitution, they are each assigned to pay a percentage of that restitution, not to exceed 100%. So previously, if a young person was charged with co-defendants, the court could assess 100% of the restitution value for each person. Again, we're talking about the restitution order, not the fine. So here's another example. If there's 3 youth that caused $3,000 in property damage, each young person would be assessed $3,000 in restitution. So now the court actually has to assess it based off of culpability or some other calculation. There's several that the courts might use, and that's on the next slide, please. So who pays what? We've outlined several options. There may actually be others that courts do, but these are the most likely based off of the mechanism of AB 1186. So the court can choose between everyone only pays for the harm they caused. So what this would look like in practice, from what we've heard attorneys, at least in Alameda County, say, is that this would likely be a hearing about determining who caused X amount of damage. So this would be assigned based off of culpability in the charges against youth. So it would be like if one juvenile broke the headlight and one broke a window, then making a determination on that and then assessing only restitution based off of that price, as opposed to just being there's $3,000 in total damage. Each youth co-defendant is on the hook for $3,000. Another option is equal division. So for an example, if there's three youth co-defendants, each would pay 33% of the full restitution order. So as long as it doesn't exceed 100%, they could divide it up as they see fit. In this case, with 3 co-defendants, 33%. If it's 2 co-defendants, just 50%. And then the final option that we've seen is that if there's agreement between all youth co-defendants on any culpability, whether that be, again, an equal division, that's fine, or somehow making a determination of culpability, then the lawyers can come to the judge and be like, my client has X amount and the other co-defendant has X amount. And typically, as far as we can see, judges are willing to stipulate that and accept those because they probably don't want to do the extra work anyways. So that is a strategy you can take as a practitioner or advocate if it's your case or your family members. What about if one of the co-defendants is charged as an adult? Unfortunately, that is actually unclear as of now. So this might depend on where you're practicing or where your case is being handled, but we are hearing from some practitioners that if the adult is found 100% responsibility in the adult adjudication, then the young person may not have to pay anything. So that could be something as a litigant or as a family member that you advocate for. If you were charged with a co-defendant who's 18 or older and you're 16 and they've already been assessed restitution fault, then that is something you can be like, well, the survivor or victim will get their compensation. I shouldn't have to pay anything. Next slide, please. So what's left based off of all these changes is that restitution for both youth and adults is still enforceable. So restitution orders as opposed to the restitution fines, as Caitlin mentioned earlier. So while there is co-defendants and you can't be assessed more than 100% fault, you are still legally allowed to be assessed restitution still as both a juvenile and adult. The second thing is that adult restitution fines may still be assessed. So if you're charged in adult court, you can still be charged adult restitution fines. However, they will be vacated after 10 years. So that is a positive development, but for those 10 years, you still can be charged for those. And then finally, any other financial penalties, including restitution, ward fines, probation, revocation, restitution fines, parole revocation, restitution fines, and any interest is all enforceable. Forward. So here we just kind of have a summary flow chart for how relief will look like. So there's several options of what you owe. If you owe adult restitution, unfortunately, AB 1186 has no impact. So you'll still have to pay for those. If it's youth restitution, AB 1186 may allow you to pay less in a property damage case. So going forward, if you are assessed restitution based off property damage, then it will have to be on that lesser evaluation like I talked about earlier. And then AB 1186 may allow you to pay less in a case with multiple youth co-defendants, as I discussed earlier as well. So if you have an active case, like Caitlin said, even if that means you're still on probation, you could probably make these arguments on behalf of yourself or your client until that you are off of probation. And finally, adult and youth restitution fines. If you have any of those, but they are older than 10 years, those should be discharged from both collections at the county, private, or any other collections agency. And to my knowledge, we are seeing that those are actually being taken off some people's books. So, and then finally, any other fines or fees, if you owe those, again, AB 1186 has no impact on those. And then finally, most importantly, if you have a case pending in juvenile court, again, even if you're on probation, you should not be assessed restitution fines. If you are, please contact whatever attorney you have, or if you are a practitioner, please advocate on behalf of your client that they should no longer be assessed those, even if there was some judicial determination prior to the first of this year, you have at least a strong legal argument that they should still not be enforced. And then for any other questions, please contact your attorney, or if you are a practitioner, we will have time for a question at the end.
Sorry, I was having difficulty unmuting. I apologize. Thank you, Caitlin and Caleb. Appreciate that. So now we're going to talk about a little bit of the more practical considerations. For example, how to request a balance owed in restitution. It can be hard to tell the difference between financial penalties. And if you want to know what you owe, you should, number one, contact the court where your case was heard. Review the types of penalties owed. Remember that restitution is still in place after AB 1186, but restitution fines are only deleted after 10 years. If you have a restitution fine, then you should have that should have been deleted. Contact a legal service provider. Importantly, it's careful when you are seeking out the balance owed. Contacting the court or a collection agency to request this balance statement could result in more aggressive collection activity. Could result in more aggressive collection measures for the court-ordered debt. Please proceed with caution, as said before, to contact one of the legal service providers that we're going to provide at the end of this presentation if you have questions about that. And finally, some of the do's and don'ts when it comes to your restitution and finding out more information about it. You're going to want to verify whether your restitution obligation is a fine or an order. You're going to want to contact your legal service providers if restitution fines are still being collected beyond 10 years. And you're going to want to request court records for clarity if it's worth the risk that we mentioned just a few moments ago. What you're not going to want to do is you don't want to assume all restitution debts are canceled. Victim restitution does remain enforceable. Do not ignore collection notices without verifying eligibility for relief. These are some of the legal service providers that can help you if you're in your journey to figure out what your restitution situation is. Those will be provided to you in the materials, but there's some right there. So at this point, I guess we would see if anybody has any questions.
I have a couple of kind of frequently asked questions that I've heard thus far. Do you want to go ahead and start with a couple of those?
Let's do it.
The first one, I guess, is an announcement, not a question, but oftentimes the way that I find people who are paying restitution have in the past distinguished whether or not something is a restitution order or a victim restitution order versus a restitution fine is figuring out where it's payable to. And oftentimes folks have said, well, this is actually not going to the survivor, this is going to the victim compensation board, or this is going to CDCR, or some other entity that's collecting. And that has kind of been a shorthand for how some folks have understood what's a fine versus an order. But one clarification I did want to make is oftentimes if a person is able to get compensation, then the payback, which basically is the collection on behalf of that person, will be done by an agency or collection program. So that money still might have gone to a person or their family directly, even if it appears that it's just a collection agency. So I just wanted to clarify, don't assume that something going to an agency or a collection program is a fine, because that might be the restitution order. Another way to that folks will sometimes consider what is a fine versus an order is if it's a nice round dollar amount. Sometimes folks will assume like, oh, if it's $150, maybe that's the fine. But I just want to caution that that should also not be a way to distinguish what's a fine versus an order, because sometimes you might see similar amounts that are also going to be the actual order of victim restitution, which is not made relievable by this act. So that's the first one. The second one was for Caleb or Caitlin. There were a couple instances where a person may be eligible for relief. So for example, if they have a case pending, or if they're on some form of supervision, could you just say a little bit more about that and clarify some of the circumstances in which somebody might be eligible for relief for an incident that happened before January?
Sure. I can maybe give a couple, and then if I am leaving anything out, Caleb, feel free to step in. So one thing that we have been hearing from some of our practitioners, specifically from EVCLC in Alameda County, is that they have been seeing the retroactivity of joint and several liability being put into effect. So just to give some context, this specific client had a restitution order from nearly a decade ago when his case was heard in an adult court, but his case was later redesignated as a juvenile case under Prop 57. And EVCLC worked and petitioned the court to apply AB 1186 so that his restitution order could be severed from his co-defendants, and they were successful in that petition. So they got rid of the joint and several liability for all of the co-parts, even though it was, an older case. And then similarly, for open cases with restitution fines, judges within Alameda County have indicated that it's pretty much a settled issue that they just remove the those fines from the probation terms. So because it's still a pending case and not final, they can remove those, and AB 1186 applies to those cases.
Yeah, the other context where that may be the case is if any of the circumstances Caitlin just described are your case is pending or you're on probation, so it's not finalized in the juvenile court. If there was a property damage assessment that was done based off of a higher amount than either the damage or replacement, then you or your attorney can make an argument essentially that that doesn't conform with AB 1186 and that it should be retroactively applied since your case is not final. And that would probably be the other circumstance where you may be granted relief. There's no guarantee. A lot of these are pretty technical, so it'll depend on what the court did in fact do, and then you'll have to contact an attorney from either the resources we provided or maybe your current attorney.
In its original form, the Repair Act, what it tried to do was create a publicly funded compensation program for survivors. So what we've been seeing is that people cannot afford to pay restitution, and so therefore victims are not able to recoup the losses that they have suffered. And so that would have created a state fund for that. It also would have established alternatives for monetary youth restitution. So like a classic community service moment. However, it was amended in 2024 to focus on restitution fines and other changes due to budgetary concerns. And we received guidance from public defenders regarding joint and several liability and other necessary juvenile restitution changes throughout the revision process. And so in its current form, it was signed in September of last year. And then, as you know, it went effective January 1st of this year. Delaney, am I missing anything?
Yeah, I think just two things I like to point out. Some people are like, what are you talking about? We already have a victim compensation system. But part of why this proposal was put into place is because the statewide victim compensation system relies on revenue that's almost exclusively from fines and fees, which, as many of us know, folks are unable to pay, even with the most kind of severe collection measures. And so that program has been kind of continuously having their resources decline, and therefore are less and less and less able to actually pay out victim compensation claims. The other issue is that the amount of money people were getting for victim compensation was a tiny fraction of what they were ordered in restitution. So they got something, which is great, but not anything near what they needed to cover their actual losses. And then finally, for folks who don't have a permanent address, whose first language is something other than English, or who have a criminal record themselves, they're rendered, or for folks who don't cooperate with law enforcement or were deemed to have participated in their own harm in some way, they were made ineligible to collect that victim compensation. So there was a ton of people who were never, ever going to get any compensation just by virtue of their own separate circumstances, basically. So this was an attempt to make a universal program that was going to actually pay the full costs of somebody's losses, as kind of a pilot to see what we could do if we kind of tinkered with the idea of a public program. Oh my gosh, Winnie. And then the second thing that I like to point out is that this bill originally was brought to Assemblymember Bonta by a group of young people in her district who came and said, hey, all of us are, we're trying to find jobs. We're trying to apply for housing, because they were kind of upperclassmen high school students who were trying to go into the workforce. And all had, realized together that restitution orders were keeping them from being able to kind of find that economic stability in their lives and actually kind of move past an incident of harm that they had caused or been on the receiving end of. So what I love about this bill so much is that it was brought by young people. And I think many of those young people also, specifically with the joint and several liability, had paid more than half of the share of a co-defendant case, and were, unable to find their co-defendant. And so we're basically perpetually stuck without relief. So we love a grassroots piece of legislation.